So your spouse or significant other doesn't want to pay child support and they're unemployed or underemployed. What do you do? Well, we've got the answer to that today. I'm Tom Marks with the Marks Law Firm in Orlando, Florida, and welcome to the Healthy Family Law Attorney. So your spouse is unemployed or underemployed. There's an answer for that in Florida Statute, Chapter 61.30. If the unemployment or underemployment is voluntary and your spouse or significant other is not mentally or physically incapacitated, then the court may impute income to your spouse or significant other for the purpose of determining the child support guidelines calculations. Okay, so you have to provide competent, substantial evidence to the court of, number one, what is the work history of your spouse or significant other? Number two, what are their work qualifications? And finally, number three, what are the prevailing earnings or incomes in the community? Okay, so the way we establish that for the court typically is by the use of what we call a VRE. That's a vocational rehabilitative expert who will evaluate your spouse or significant other to determine what are their work qualifications, what is their work history, what are the prevailing earnings in the community. So let's say your spouse has had a history of making a six-figure income, but all of a sudden you're in the middle of a divorce or paternity action and they're facing a child support obligation and their income has dropped substantially. We call that in family law RAIDS, recently acquired income deficiency syndrome. That's where the spouse or significant other doesn't want to pay child support and all of a sudden they're no longer making the income they were before, they're getting paid under the table, they're getting unemployment compensation or something of that nature. So the VRE evaluates the spouse, significant other, determines they have the ability to work, they're voluntarily unemployed or underemployed, that the prevailing earnings in the community are substantially higher than what they're earning. So for example, I had a case one time where the husband had a master's degree, had historically made a six-figure income, and now was only making $25,000 a year. We had him evaluated, presented that testimony and evidence to the court, and the court imputed an income of $125,000. And so we based the child support on that higher income. So the child support was substantially higher than it would have been if we had used the $25,000 per year as what arguably was his actual income, but he was voluntarily underemployed. Okay, so what do you do if the other parent is not willing to participate in the proceedings or doesn't provide the financial information needed to impute that income? Well, the court can automatically impute income at the median income in the community, which in the Orlando area right now is over $50,000 a year. So that's an easy out for the court unless you want to go for a higher imputed income. So there are a couple of outs for a parent you're trying to impose an imputed income to. One is if the court finds it's necessary for that parent to stay at home with the minor children, or for some other reason the court shouldn't impute income, those arguments can be made. Also, you can't use income of a party that's more than 5 years old. So you can't look back and say, 10 years ago, he or she made $75,000 and now they're only making $15,000 a year. And you can't impute an income to a party above what they've ever made historically, unless they've recently been licensed in some new profession, like they just passed the Florida bar exam and they're going to be a practicing attorney or a medical doctor or something of that nature. Okay, so your spouse or significant other cannot get away with not working full time just because they want to avoid child support. I will say that imputation of income can also come into play for determining alimony and also the ability to pay attorney's fees. I've done prior videos on alimony and attorney's fees, but you need to establish their ability to pay those, and imputation of income is one way to do that. I know that's a new term for most people, but I hope this is helpful to people trying to make sure they get the right amount of child support, maybe alimony and attorney's fees also. So I believe your family matters, so I want to provide hope and help to your family to successfully navigate the family law process in a healthy way. I hope this has been helpful. Hit that like and subscribe button, hit that bell icon. Please leave a comment, or if you want to hear any other topics or have questions, just leave it in the comment section below. And I hope you have a great week, and I'll see you next time. Bye.